Welcome back to the deep dive. Today we are tackling one of the most intellectually difficult and, frankly, heartbreaking areas of tort law. How do we assign a monetary value to human suffering, to loss of life's pleasures, especially when the victim is so hurt they can't even perceive what they've lost?
It really is the ultimate test of what we mean by compensation. Our mission in this deep dive is to analyze a landmark case, McDougald v. Garber. This case really drew a bright line in the sand. It defined the rules for non-pecuniary damage recovery when consciousness itself is destroyed.
Okay, let's set this up right away. The court wasn't fighting over if money was due, but over what kind of money. This whole case turns on the difference between two types of recovery. First, let's define pecuniary damages.
Pecuniary damages are, the calculable economic losses. Think of them as things you can put on a spreadsheet. Medical expenses, lost earnings, the huge cost of long-term care. And this is critical. In McDougald, the awards for lost earnings, that was around $770,000, and future care, over $2 million. Those were basically uncontested by the court. They represented a real, objective economic loss.
So the entire legal fight was about the second, much more subjective type, non-pecuniary damages.
Exactly. This is where it gets tricky. These damages are supposed to compensate for the emotional and physical consequences of the injury. We're talking about pain and suffering, and what the law calls loss of enjoyment of life. This is where the legal fiction that money can somehow make up for not being able to walk or feel joy just collides with a terrible reality.
And when dealing with a plaintiff in a coma, what were the two critical questions the court had to answer about these non-pecuniary damages?
The first, and it's a really profound question, was, do you need to be cognitively aware to be compensated for losing the enjoyment of life? I mean, if you don't know what you've lost, can the law pay you for it? And the second question was more procedural, but just as important. Should loss of enjoyment of life be awarded separately from pain and suffering?
Let's jump right into that first one. This idea of compensating someone for lost experiences, seeing art, being with family. Must the injured person actually be aware that those things are gone?
This is where you see this tension between our compassion and the strict purpose of the law. The general rule in civil damages is that these awards have to serve a concrete compensatory goal. They're meant to provide some sort of solace or utility to the victim. If that's impossible, the court argues, the award stops being compensation and starts becoming punishment.
That's a fascinating but very cold assessment. It implies that if a victim is damaged badly enough, if their brain is totally offline, the defendant actually gets a financial break on these damages.
That is exactly the paradox the court had to wrestle with.
Okay, let's analyze McDougald v. Garber to test this rule. So first, what are the legally dispositive facts?
The plaintiff, Emma McDougald, suffered severe oxygen deprivation during a surgery back in 1978. It caused catastrophic brain damage, leaving her in a permanent comatose condition. Now, crucially, the trial had a lot of debate about how much, if any, cognitive ability she had left. But the consensus was she was permanently impaired, maybe completely unaware. The jury originally gave her $3.5 million separately just for the loss of enjoyment of life.
And what was the core legal issue that came out of that award?
The precise legal issue was whether some degree of cognitive awareness is an absolute prerequisite to recover damages for loss of enjoyment of life.
So what rule of law did the court apply? Could you state the full black-letter rule and break it down into its testable elements for us?
Yes. The court held that cognitive awareness is a prerequisite for any non-pecuniary damages. The test is just some level of awareness. And the rule is based entirely on the compensatory purpose of civil damages. So it really has two necessary elements you have to meet. First, element one, the award must serve a compensatory purpose. It has to provide some meaningful utility or solace to the person. And element two, the award cannot be purely punitive. It can't just be about punishing the wrongdoer for how bad the harm was.
Thank you. Okay, now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the requirement of a compensatory purpose, to Mrs. McDougald's condition?
Okay, so for element one, the court basically reasoned that if an injured person is totally cut off from any awareness of their loss, if they're in a persistent coma, then a money award has, and this is a quote, no meaning or utility to them. They can't spend it. They can't get any consolation from it. The money just sits there. So without that awareness, the element of compensation just isn't met.
Got it. So if the money can't actually help the victim, then its only other purpose is to punish the defendant. That brings us to the second element, the rule against purely punitive damages. The court even mentioned this paradoxical situation where a more severe injury leads to a smaller award. How did they use this anti-punitive element to justify that?
This is really the ethical heart of the decision. For element 2, the court identified this temptation they called retributive symmetry, this urge to make the punishment fit the crime, so to speak.
Uh-huh.
But the court stressed that urge comes from criminal law. It has, quote, no place in the law of civil damages for simple negligence. Civil law is about making the victim whole, not punishing the defendant in proportion to the horror of what happened. So by requiring awareness, the court forces the focus back on the victim's actual conscious loss, and it stops the award from becoming a backdoor punitive fine.
That makes the line much clearer, even if it's still hard to accept. The law is basically saying, we measure your loss by your ability to feel that loss.
That's it, exactly. It's a focus on the subjective experience of the victim, not the objective severity of the harm caused by the defendant.
So, after analyzing both the lack of utility and the risk of punitive damages, what was the court's final conclusion on the awareness issue?
The court concluded that cognitive awareness is, in fact, a prerequisite. The trial court was wrong to tell the jury that Mrs. McDougald's awareness didn't matter. And crucially, they set a very low bar, just some level of awareness. They did that on purpose to avoid these endless, speculative legal battles over different degrees of brain function.
Okay, here's where it gets really interesting. Let's use a visceral scenario to lock this in. Imagine a defendant negligently starts a fire. It destroys a priceless collection of vintage comic books. That's a clear economic loss. Now, in that same fire, a professional comic book illustrator is put into a permanent coma. In both cases, the defendant caused an identical loss, the ability to enjoy that art. So why is the compensation treated so differently?
The difference is simple. It's the objectivity of the loss versus the subjectivity of the recovery. The comic book collection, that's a pecuniary loss. You can value it, compensate it with money, and that money benefits the owner's estate. It has utility. The comatose illustrator's loss of the enjoyment of drawing, that's non-pecuniary. Because the illustrator lacks that some level of awareness, giving them a big monetary award violates the McDougald rule. It would be punitive, not compensatory, because the victim can't get any solace or pleasure from the money.
That's a perfect transition to the second major issue. So let's assume a plaintiff does meet the awareness threshold. They're conscious, they're suffering. The jury in this case gave separate awards. $1 million for pain and suffering, and $3.5 million for loss of enjoyment of life. So should these two types of suffering be separated for the jury, or should they be combined?
This really gets into managing juries and preventing excessive awards. The general rule here is pretty traditional. Plaintiff's inability to enjoy life has, for a long time, just been seen as one factor to be considered in a general award for what we call pain and suffering.
Okay, so what rule of law did the court apply on the segregation issue? Can you state the full black-letter rule?
The rule is that loss of enjoyment of life should not be treated as a separate category of damages. It should be subsumed within the general award for pain and suffering.
All right, now for the court's elemental analysis on that point. The lawyers arguing for separate awards claimed you can distinguish them analytically. You know, the physical response to pain versus the emotional response to your life being limited. How did the court apply the element of analytical precision to reject that idea?
The court actually agreed that, yes, you can distinguish those concepts. One is the immediate ouch, the other is the deeper sadness about what you can no longer do. However, they said that putting a dollar amount on non-pecuniary damages is, quote, not amenable to such analytical precision. The whole process of turning suffering into dollars is already a legal fiction, right?
Right, it's a murky process, as they called it.
Exactly. And asking a jury to break that murky process down into even smaller pieces would just amplify the distortion. It hugely increases the risk of the jury awarding duplicate damages.
You mean they might award money for the pain and then award more money for the anguish that the pain is causing, so you're basically paying for the same thing twice.
That's the exact fear. If you tell a jury to award for pain and then also award for the inability to enjoy life because of the pain, there's this huge risk they're compensating the same injury 2 times over. The court wanted to contain that.
So after looking at that risk of duplication, what was the court's final conclusion on the segregation issue?
The conclusion was that no good purpose is served by separate awards. In fact, it's dangerous. So the trial court was wrong to tell the jury to consider loss of enjoyment of life separately. Both conscious pain and suffering and loss of enjoyment of life must be combined into one single general award for non-pecuniary damages.
So what does this all mean? For someone listening who's prepping for an exam or maybe even working on a case like this, let's synthesize these rules into a clear step-by-step checklist.
Absolutely. This is your exam framework checklist for non-pecuniary damages under McDougald. It's
Hmm.
a three-step tool. Number one, identify the damage type. First, you have to separate the pecuniary damages, medical bills, lost wages, from the non-pecuniary ones. The McDougald rules only apply to the non-pecuniary stuff.
Okay, separate the economic from the non-economic. What's step two?
Step two, test the threshold. For those non-pecuniary damages, you immediately have to look for evidence of some level of awareness. If your facts show a total and permanent coma, that non-pecuniary claim is likely going to fail. The court requires a subjective experience of loss.
And if the awareness threshold is met?
Then you move to step three, combine the claim. If there is awareness, you have to make sure that the total non-pecuniary claim combines everything. Loss of enjoyment of life is not its own separate thing. It is just a factor inside the single general award for pain and suffering.
This case is just so powerful because it lays bare this core conflict, doesn't it? The tension between our moral desire to make a defendant pay for the sheer awfulness of the injury and this very strict legal rule that civil damages have to actually benefit the victim.
And that leads to a final provocative thought for you to think about. The court made a very conscious choice here. They chose simplicity, one P&S category, one simple some awareness standard, over what they admitted could be a more precise analysis. So by simplifying things to avoid punitive awards, does that decision truly guarantee that all of the victims' distinct forms of conscious loss are compensated? Or does it risk, minimizing the profound non-physical suffering that comes from knowing your life is permanently and fundamentally broken? What stands out to you?